Good afternoon. My name is Erwin Chemerinksy, and it's such an honor and pleasure to be with you. Now, I was told that I have 50 minutes to talk about the Supreme Court, but you've heard the prior session, you know that the average attention span is only 20 minutes. Everything changed in the United States Supreme Court on Saturday, February 13th, when Justice Antonin Scalia passed away. For the longer term, everything changed in the Supreme Court on Tuesday, November the 8th. From 1971, when Richard Nixon's third and fourth appointees to the Supreme Court were confirmed, until February 13th, 2016, there were always as many as 5, and sometimes as many as 8 justices appointed by Republican presidents. Now, of course, there are 4. Is this working? Okay. Now, of course, there are 4 justices who are appointed by Republican presidents: Roberts, Kennedy, Thomas, and Alito. 4 appointed by Democratic presidents: Ginsburg, Breyer, Sotomayor, and Kagan. If Chief Judge Merrick Garland had been appointed to the Supreme Court, there would be, for the first time since 1971, 5 justices appointed by Democratic presidents. If Hillary Clinton had been elected president, there'd be a Democratic majority, likely for decades to come. But now, Antonin Scalia is going to be replaced by a conservative Republican. It will restore the court's ideological balance to what it was before February 13th. And if there's another vacancy on the court in the next 4 years, it will mean a conservative majority on the court for decades to come. Given that I have 50 minutes, and that I've been told that the attention span is 20 minutes, I'm not going to try to go through a large number of cases in a short period of time. Instead, what I'd like to do is make 5 points about the court, looking at it last year, looking at this year, looking at Neil Gorsuch, and looking at the longer-term future of the court. I have prepared in the materials a handout that lists the major decisions from last term and the major matters on the docket for this term, and I give the citations to them, and I'll certainly be drawing as examples from those cases. I want to make 5 points about the Supreme Court. The first is easily stated: deadlock. Once Justice Scalia passed away on February 13th, there's a substantial likelihood there'd be a significant number of cases where the justices were deadlocked 4-4. If you look at the prior decade, on average, there were 10 cases a year that were 5-4 with Justice Scalia in the majority. Last term, October term 2015, there were 5 cases where the justices deadlocked 4-4, announced that they were affirming the lower court without decision by an evenly divided court. One was Hawkins versus Bank of Raymore. It was an issue about the Equal Credit Opportunity Act. One was Franchise Tax Board versus Hyatt, whether a state can continue to be sued in another state's court. One was Dollar General versus Choctaw Nation, whether a tribal court can hear a civil suit against non-tribal members. A 4th case was Friedrichs versus California Teachers Association. The issue was whether non-union members can be required to pay the share of the union dues that go to support the collective bargaining activities of the union. And the final case with the justices deadlocked 4-4 was United States versus Texas, that involved President Obama's immigration action, deferred action for parents of Americans. In each of these cases, the lower court's ruling stands. There's no Supreme Court opinion. The justices are free, of course, to take up the issue again in the future. But it's important to note that when the justices are tied 4-4, they have other options besides affirming the lower court by an evenly divided court, as they did in the matters I just mentioned. They can look for a compromise. They can try to find a narrow ground that a majority can agree upon. That happened a number of times last term, and I'm convinced it's going to happen a number of times on the cases on this year's docket. The most high-profile instance of this last year was a case called Zubik versus Burwell, and it involved the so-called contraceptive mandate of the Affordable Care Act. After oral argument, it was clear that the justices were going to be deadlocked 4-4. The court then did something that I've never seen before. It may be unprecedented. The justices issued an order where they proposed a compromise and they asked for the parties to brief it. One side, the religious institutions, filed briefs saying the compromise looked great to them. The other side, the United States government, filed briefs saying it won't work. The justices then issued a short per curiam opinion saying, since both sides see a viable compromise, the court was going to send the case back to the lower courts. That happened in April. Nothing has occurred in these cases since, though in all likelihood, these regulations and maybe the Affordable Care Act will be repealed. There's yet another option available to the justices when they're deadlocked. They could put a case over for re-argument the following year. Tradition is that a case is decided the term in which it's argued. But there have been many high-profile cases that were argued one year, not decided then, put over for re-argument, and decided the following year. Brown versus Board of Education, Roe versus Wade, Citizens United versus Federal Election Commission were all argued one year, not decided that term, and put over for re-argument. One thing that's interesting about last year in the court, October term 2015, that didn't happen even one time. I think there's an easy explanation. The justices knew that it was no more likely that being 9 justices on the bench in this October term 2016 there were 9 justices on the bench last year, October term 2015. Senate Republicans made clear from the day of Justice Scalia's death that there would be no hearings, there would be no vote on whoever President Obama nominated for the Supreme Court. Chief Judge Merrick Garland went longer from the time of nomination, there's no hearing, than any in American history. What occurred in 2016 was truly unprecedented. There were 24 prior instances in American history where there was a vacancy in the last year of a president's term. In 21, the individual was confirmed. In 3, the individual was denied confirmation. Never before had the Senate said, no hearings and no vote. I should disclose to you, I've known Merrick Garland since the late 1960s when we were competitor high school debaters in the Chicago area. We also went to law school together. He was a year ahead of me in law school. In fact, the morning President Obama nominated for the Supreme Court, my oldest son called me and said, you've known him a long time, what do you think of him? And I said that I thought that Merrick was a brilliant man. He's truly a decent person. And I said to my son, look at it this way. Merrick Garland is a Jewish man in his early 60s who had Eastern European grandparents. He grew up in the Chicago area. He was a high school debater. He went to Harvard Law School. I can also say he's about 5'7", has gray hair, and wears glasses. What's not to like about all of that? I predict that this year there will be some cases that the justices don't decide and put over for re-argument next year. In order for a justice to participate in a decision, he or she has to be on the bench both at the time of the oral argument and at the time the decision comes down. At the earliest, Neil Gorsuch could be on the Supreme Court for the April argument calendar, the last of the term. And so for everything else, and if he's not on the term in April, there's going to be some 4-4 ties. And I think the justice may well say, let's have it re-argued next year. So that's my first theme about the court, deadlock, how important it is to understanding last year, and I predict this year. Second, I want to talk about last term, October term 2015, and I can easily summarize it for you. It's the Anthony Kennedy Court. Last year, the Supreme Court decided 63 cases after briefing and oral argument. That's the fewest number since at least 1932, which is as far back as I can find statistics. Justice Anthony Kennedy was the majority in 98% of all of the decisions. I can't find any term in recent memory where one justice was the majority 98% of the time. If you happen to have a case in the Supreme Court now, I'd advise you to make your brief a shameless attempt to pander to Justice Kennedy. If the clerk will allow it, put Justice Kennedy's picture on the front of your brief. I think the significance of Justice Kennedy's vote was most evident in two decisions last term. I think they were the two most important cases of the term, just in terms of human impact. One of these involved affirmative action. The case was Fisher versus University of Texas at Austin. In June 2003, in Grutter versus Bollinger, the Supreme Court held that colleges and universities have a compelling interest in having a diverse student body. The court said that colleges and universities may use race as one factor in admissions decisions to benefit minorities and enhance diversity. The next year, 2004, the regents of the University of Texas adopted a new admissions plan for their undergraduate students. The regents said that they saw that their university was less racially diverse than it had been even 8 years earlier. There were fewer African American students at the University of Texas in 2004 than there had been in 1996. So the regents said, pursuant to Texas state law, about 75% of each entering class would be accepted by taking the top 10% from every high school in the state. Texas is sufficiently racially segregated that would produce some degree of diversity. But it still wouldn't get Texas back to even the pre-1996 levels of diversity. So the regents said, for the other, about 25% of each entering class, they would do an individualized review of every application. For each applicant, an admissions score was calculated. The score is the sum of two numbers. One is called the Academic Achievement Index. That's the student's grades and test scores. The other is called the Personal Achievement Index. This looked at the applicant in terms of 7 factors. One of the 7 factors is what the student would contribute to diversity at the University of Texas. The regents and their lawyers felt that the university was doing just what the Supreme Court prescribed, using race as one of many factors in admissions decisions. Abigail Fisher, a white woman, applied for the University of Texas in 2008. She wasn't in the top 10% of her high school graduating class. She wasn't admitted through the review of her file. She enrolled in Louisiana State University, from which she graduated in 2012. When she was denied admission to the University of Texas, she sued and said that its consideration of race violated equal protection. I can only imagine what her alma mater, Louisiana State University, feels in hearing her say that she was terribly injured in having to go to Louisiana State University rather than her preferred school, the University of Texas. The federal district court ruled against her based on Grutter versus Bollinger. The United States Court of Appeals for the Fifth Circuit ruled against her and in favor of the University of Texas. The Supreme Court granted review, and they had oral argument in October of 2012. But the court didn't hand down a decision until June 24th, 2013. Joan Piskubic, who covers the Supreme Court for Reuters and CNN, and this year is a visiting professor at my law school, got several of the justices to talk to her. And the justices told her, and this is in her book called Breaking In, that when the justices first voted in conference in October of 2012, it was going to be 5-3 to declare the Texas program unconstitutional and to largely overrule Grutter versus Bollinger. The reason it went 5-3 then is Justice Kagan was recused from the case because she was involved in it as Solicitor General. But from when the justices told Joan Piskubic, Justice Sotomayor wrote a blistering dissent defending affirmative action, and Justice Kennedy convinced enough of the other justices that there was no need to overrule Grutter, no need to rule against the University of Texas. They could decide on much narrower grounds. And on Monday, June 24th, 2013, the court handed down its decision. It was 7-1. Justice Kennedy wrote, only Justice Ginsburg dissented. In writing for the court, Justice Kennedy said that it's not enough that a college or university have a compelling interest in a diverse student body. The college or university has to prove there is no other way to achieve diversity. He said no deference should be given to college universities in this determination. The court sent the case back to the Fifth Circuit. In the summer of 2014, the Fifth Circuit 2-1 again ruled in favor of the University of Texas. The Supreme Court granted review. The Supreme Court handed down its decision on Thursday, June 23, 2016. In a 4-3 decision, the Supreme Court affirmed the Fifth Circuit and ruled in favor of the University of Texas. Justice Kennedy wrote the opinion for the court, joined by Justice Ginsburg, Breyer, and Sotomayor. Justice Alito wrote a vehement 52-page dissent, joined by Chief Justice Roberts. Justice Thomas wrote a separate dissent. Anthony Kennedy came on the Supreme Court in February 1988. From then until Thursday, June 23rd, he had never voted to uphold any affirmative action program in any context. Not in education, not in contracting, not in employment. In the first affirmative action case where Justice Kennedy participated, Metro Broadcasting versus FCC in 1990, he wrote a blistering dissent likening affirmative action to apartheid and saying the Constitution requires that the government be colorblind. But in Fisher versus University of Texas at Austin, on June 23rd of 2016, Justice Kennedy said, colleges and universities have a compelling interest in having a diverse student body. He said, Texas proved the need for diversity. He said, Texas demonstrated that there was no other way to achieve diversity. Perhaps most important, at the end of his opinion, he said, deference should be given to colleges and universities in terms of the need for diversity and how to achieve it. Justice Alito began his dissent by saying, something strange has happened in the Supreme Court since the last time the case was here. I think what's strange is that Justice Kennedy has changed his views with regard to affirmative action. And for those who believe that affirmative action is necessary to remedy past discrimination, to ensure diversity, this case is an enormous victory. The other case that I want to talk about from last term concerns abortion rights. And the case is Whole Women's Health versus Hellerstedt. I mentioned to you a moment ago that Anthony Kennedy came on the Supreme Court in February 1988. From then until Monday, June 27th, only once before had Anthony Kennedy voted to strike down a restriction on abortion. That was in 1992 in Planned Parenthood versus Casey. We voted with the majority to declare unconstitutional a part of a Pennsylvania law that required the married woman notify her husband before getting an abortion. Otherwise, in every abortion case, Justice Kennedy voted to uphold the state or federal laws. But on Monday, June 27th, Kennedy was part of a 5-person majority to strike down a Texas law limiting abortions. Did you know that from 2010 to 2015, state legislatures across the country adopted over 290 new laws imposing restrictions on abortion? These laws are sometimes called targeted restriction of abortion providers. The first of these to come to the court was from Texas. In the Texas legislature, it was called HB 2. You might remember Wendy Davis leading an unsuccessful filibuster against it on the floor of the Texas legislature. There were 2 provisions of the Texas law at issue before the Supreme Court. One said that in order for a doctor to perform an abortion, he or she had to have admitting privilege at a hospital within 30 miles. Generally, these hospitals won't give admitting privileges. Sometimes it's because the hospital is religiously affiliated. Often it's because the hospital requires that in order for a doctor to have admitting privileges, he or she has to admit a minimum number of patients per year. Abortion is such a safe procedure, rarely do the doctors need to admit patients. The other provision said that in order for a facility to have abortions performed there, it'd have surgical quality facilities. It'd have hallways big enough for 2 gurneys. It'd have the HVAC facilities used in hospital operating rooms. Before Texas adopted its law, there were 40 facilities in the state where abortion performed. When the law was enacted, 20 of those facilities closed. The parties agreed that if the Supreme Court upheld the Texas law, there were only 7 or 8 facilities in the state where abortion would be performed. Federal district court in Texas issued a preliminary injunction against the law. The district court said there's no evidence that the law would do anything to protect women's health. The district court said there's no need for the doctor to have admitting privileges at a hospital. If a woman was having complications, she'd be taken to the emergency room and the doctors there would provide treatment. The district court said no need for surgical quality facilities, no surgical procedures being performed. No need for hallways big enough for 2 gurneys, gurneys weren't used. The United States Court of Appeals for the Fifth Circuit reversed. The Fifth Circuit said it should be for the Texas legislature, not for the courts, to decide if the burdens with regard to access to abortion are justified with regard to the benefits in terms of protecting women's health. On Monday, June 27th, the Supreme Court 5-3 reversed the Fifth Circuit. Justice Breyer wrote for the court, joined by Justices Kennedy, Ginsburg, Sotomayor, and Kagan. Justice Breyer emphatically said it's for the judiciary to decide whether the benefits in protecting women's health justify the burdens in terms of access to abortion. The court relied on the fact-finding of the district court and said there's no evidence that these restrictions would do anything to protect women's health. If Justice Kennedy had voted with Chief Justice Roberts and Justice Thomas and Alito, it would have been a 4-4 tie. The Fifth Circuit decision upheld, the Texas law would have gone into effect. Justice Ginsburg wrote a short concurring opinion saying, be clear, this means that all of these recently adopted targeted restriction of abortion provider laws are unconstitutional. In fact, in the half years since, a number of federal district courts around the country have struck down those state laws. So if that's what was most important about October term 2015, let me go to my third point, which looks at this term, October term 2016. And this, I think, is a term that you can only understand through the prism of the possibility of deadlock. You can only understand it, reality, there are 8 justices on the court. That's manifest in so many ways. It's manifest on the topics that are on the docket. There aren't the hot-button issues before the court this term, like affirmative action, or abortion, or gun rights, or others that are likely to be ideologically divisive. It was manifest in terms of the pace at which the justices granted review. For a long time, it looked like the justices weren't even going to get to 60 decisions this year, not even matching last year's record modern low of 63. And then the justices took 16 cases on Friday, January 9th, and a couple of more cases on January 19th. So now again, they'll be back into the mid-60s. One other interesting thing about this term that reflects the possibility of deadlock. There were 3 cases where review was granted in January 2016, but they've not yet been scheduled for oral argument. Every case where review was granted last June has been heard. All the cases that review was granted at the end of September have been scheduled. But there's 3 cases that the justices are waiting to schedule for oral argument. One of these cases is Trinity Lutheran of Columbia, Missouri versus Pauley. State of Missouri has a plan where it gives material to schools in the state to put on the bottom of playgrounds. They take scrap tires, they shred them, and so they give them to schools. And that way, if a kid falls, there's a soft landing. And the state of Missouri will give this to all of the public schools and to the secular private schools in the state, but not to the religious schools. It's based on a provision in the Missouri Constitution that limits aid to religious institutions. Religious schools that couldn't get this aid brought a challenge saying that it infringes their free exercise of religion and it denies equal protection. The United States Court of Appeals for the 8th Circuit, in a 2-1 decision, upheld the Missouri law. The Supreme Court granted review. Most Supreme Court cases over the years involving aid to religion have involved whether or not a particular form of assistance given to a religious institution, like religious school, violates the Establishment Clause. This is interesting because it involves the question of when does the failure to give aid to a religious school violate the Constitution? The second case that had review granted in January 2016 but hasn't been scheduled for oral argument is Murr versus Wisconsin. It involves what is the piece of property for purpose of the Takings Clause of the Constitution. The Takings Clause, as you know, says the government can take private property for public use, but must pay just compensation. There's 2 ways of finding a taking. One is a possessory taking. That's where the government physically occupies or confiscates the property. The other that's involved in this case is a regulatory taking. That's where government regulation prevents any economically viable use of the property. Murr versus Wisconsin involves how do you decide what's the property for purpose of regulatory taking. For those of you who do land use work, this is enormously important. What's involved in this case is two adjacent parcels of land. They're both owned by the same family, but in different trusts. Wisconsin adopted a law that prevented all of the development of one of those parcels while still allowing the development of the other parcel. Should it be considered one piece of property? In that case, it's not a regulatory taking because there's still development allowed of some of it. Or should each be considered a separate piece of property so that the preclusion of development in one is a regulatory taking? The final case where review was granted last term, but it hasn't been scheduled yet for argument, is a case called Microsoft versus Baker. My law students are particularly interested in it because it involves the Xbox. Turns out that there's a glitch in the Xbox for some of them, and it causes serious malfunction. A class action suit was brought in federal district court. The judge refused to certify the class action. Generally, the denial of class certification is not immediately appealable. So the plaintiffs dismissed their case with prejudice so as to be able to appeal the judge's denial of class certification. Is that permissible? The Ninth Circuit said yes. The Supreme Court granted review. Now, in terms of the cases that have been scheduled for oral argument, there are a number in varying areas that are quite important to your work. Let me talk first about the criminal cases on the docket. I think the two most important criminal cases, especially in federal court, are follow-ups to a Supreme Court decision from June 26, 2015, Johnson versus United States. In Johnson, the Supreme Court declared unconstitutional on vagueness grounds the residual clause of the Armed Career Criminal Act. If you don't practice criminal law, the Armed Career Criminal Act is a federal statute. It says if a person used a firearm in a crime of violence, and they have 3 prior convictions for crimes of violence, there's a mandatory minimum sentence of 15 years in prison. Crimes of violence is defined in categories. Arson and burglary is a category. The last category is called the residual clause. It says, or another crime with a serious risk of physical injury to a person. In Johnson, the Supreme Court 8-1 said the residual clause is unconstitutional. In Welch versus United States last term, the court 7-1 said that Johnson applies retroactively to those whose sentences were final before June 26, 2015. As soon as Johnson came down, I did a quick Westlaw search. And I'm not very good on Westlaw, but I quickly found over a dozen federal statutes and sentencing guideline provisions that use the same language as the residual clause of the Armed Career Criminal Act. I did a quick search as to California law, and I found several California statutes that use the same language. The question is, will Johnson versus United States be extended beyond the Armed Career Criminal Act to these statute and sentencing guideline provisions? There's 2 cases on the docket this term about that. And if you practice criminal law, especially in federal court, these will be enormously important to you. Beckles versus United States involves the question of whether a provision of the federal sentencing guidelines to use the same language as the residual clause is unconstitutional on vagueness grounds. Lynch versus DeMaya, argued a couple of weeks ago, involves a question of whether a provision of the immigration statute that uses the same language as the residual clause is unconstitutional on vagueness grounds. If the court extends Johnson to the sentencing guidelines to other statutes, it will open the door to challenges in so many other areas. And again, many states have their own statutes with similar language. With regard to the First Amendment, I think the most important free speech case of the term is Lee versus Tam. Simon Tam is the head of a rock group out of Portland, Oregon. All of the members of the rock group are Asian American. They decided they wanted to call their band the Slants. Slants is a derogatory term, sometimes directed at Asians. They felt that by calling their band this term, they'd be appropriating it back for use by the Asian community, no longer be a slur. They analogized to how the gay and lesbian community has taken the word queer, which used to be a slur, and appropriated it back. However, an officer in the trademark office refused to allow them to register the trademark for the band, the slants. The trademark statute doesn't allow registration of trademarks if they're derogatory to another person or group. And on appeal within the Patent and Trademark Office, this was affirmed. But the United States Court of Appeals for the Federal Circuit, an en banc decision, declared the statute facially unconstitutional. The Federal Circuit said, this is a viewpoint discrimination with regard to speech. If anything runs afoul of the First Amendment, it's viewpoint discrimination. I don't like making predictions about what the Supreme Court's going to do. I long ago learned that he who lives by the crystal ball has to learn to eat ground glass. But here I have a prediction, and it's an unusual one. I think the United States Court of Appeals for the Federal Circuit is going to get affirmed. If you do anything in the field of patent law, you know the safest prediction is the Federal Circuit's going to get reversed. It gets reversed all the time by the Supreme Court. But I don't think so here. I've read the transcript of the oral argument, and I think a majority of the justices were very much sympathetic with the position of the Federal Circuit. On the one hand, of course, there's desire to eliminate slurs and derogatory language. On the other hand, could Congress pass a law saying no book could be copyrighted if it had racist language or used epithets? Wouldn't that clearly violate the First Amendment? Is this really any different? The final area that I want to talk about in terms of this term, civil rights cases. I think that this is going to be a very important year for statutory civil rights cases before the Supreme Court. Let me give you a couple of examples of this. One example is two cases that were consolidated for oral argument. They were argued on Tuesday, November the 8th, which is why you didn't get much media attention about them. The Bank of America versus City of Miami and Wells Fargo versus City of Miami. Now, I should disclose here, I've been co-counsel for the City of Miami since the very beginning of this litigation. City of Miami's claim is that these two banks intentionally directed very undesirable, high-risk loans to African American and Latino borrowers. When the foreseeable happened and there was default, the banks refused to offer refinancing on the same terms it was giving to white borrowers. The predictable happened and there were foreclosures. The city is suing the banks under the Fair Housing Act. The Fair Housing Act allows any aggrieved person to have standing to sue. The federal district court in Miami dismissed the case. The district court said the city of Miami itself didn't suffer any injury. It wasn't discriminated against. Therefore, it shouldn't be able to sue. The United States Court of Appeals for the 11th Circuit reversed. The 11th Circuit said that Miami presented claims that it was injured. It said it had lost tax revenue because of the foreclosures. There's more law enforcement costs when there's abandoned buildings. Miami said its goal of interracial housing was being frustrated. The 11th Circuit said that the city did have standing to challenge the so-called predatory lending. I've studied the transcript of the oral argument. My best guess is that the justices are split 4-4 on this issue. And it'll be interesting to see if that prediction comes true. Do they affirm the lower court by an evenly divided court, or do they put it over for re-argument when there's a ninth justice? But there's a lot of civil rights statutes that use similar language, so the question of standing is certainly important. The other statutory civil rights case is the one that will get the most media attention this term. I think of everything that's on the docket. The case is Gloucester County Board of Education versus GG. GG is the student's initials. GG was born biologically female. Before high school, GG decided male. Before 10th grade, GG changed first names to have a male first name and asked to be addressed only with male pronouns. GG asked for permission to be able to use the boys' restroom. The school said no, that GG could not use the boys' restroom, but GG could go use a restroom in the nurse's office. Gigi's parents felt that that was stigmatizing. They brought a lawsuit in federal district court. Meanwhile, the school board passed a resolution saying that every student had to use the restroom and locker room that corresponded to the student's sex as of birth. This is not a constitutional claim. It's a claim that's brought under Title IX, which applies to educational institutions that receive federal funds. Title IX says that educational institutions that receive federal funds cannot discriminate based on sex. The Department of Education sent out a letter saying that it interpreted Title IX that discrimination against transgender students was a form of sex discrimination. In fact, in May of 2016, the Department of Education, Department of Justice sent out a joint Dear Colleagues letter saying they interpreted Title IX so that the discrimination against transgender students was sex discrimination, violation of the statute. The district court rules against Gigi. The United States Court of Appeals for the Fourth Circuit in a 2-to-1 decision reverses, and the United States Supreme Court grants review. The case is going to be heard in March before the court. Again, I think there's reason to believe that the justices could be split 4-4, and we'll see whether they affirm the lower court by an evenly divided court if that happens, or if they put it over for re-argument next term. But this, of course, is the first time the Supreme Court's ever dealt with the issue of transgender discrimination, either under federal statute, though not present here, under the Constitution. The fourth thing that I wanted to talk about today is the nomination of Judge Neil Gorsuch for the United States Supreme Court. There is no doubt that Neil Gorsuch is impeccably qualified to be on the Supreme Court. He's a graduate of Columbia University and Harvard Law School. He has an advanced degree from Oxford University. He went on Marshall Fellowship. He clerked on the D.C. Circuit for Judge David Sentel. He clerked on the United States Supreme Court for Byron White and Anthony Kennedy. He was in private practice, held a high-level position in the Justice Department in the Bush administration, and for 10 years now, he's been a judge in the United States Court of Appeals for the 10th Circuit. You don't get a better resume than that. On the other hand, there's also no doubt that Neil Gorsuch is very conservative. You can see this in the National Review's statement, in Ted Cruz's statement on Wednesday, that Neil Gorsuch is, in their view, a grand slam home run. If you look at Neil Gorsuch's record as a 10th Circuit judge, you certainly see that he's quite conservative. Like Justice Scalia, he rejects the notion of a wall that separates church and state. He repeatedly ruled in favor of allowing religious symbols on government property. In the cases under the Affordable Care Act, the contraceptive mandate, a couple of them ruled in favor of religious institutions and said that it substantially burdened their religion to have to provide insurance for contraceptives for women employees. He's consistently favored employers over employees in employment discrimination cases, police over victims in excessive force cases. I think one of the things that will be most troubling to the Democratic senators, he's a self-avowed originalist. Remember in 1987, Robert Bork was denied confirmation on the Supreme Court because of his originalist views. His views that there's no constitutional right to privacy, including for reproductive autonomy. His views that from an originalist perspective, there's no protection for women against sex discrimination. From an originalist perspective, of course, there'd be no right to marriage equality for gays and lesbians. In a number of different places, Judge Gorsuch has said that he believes that the meaning of a constitutional provision is fixed when it's adopted. It's changeable only through the amendment process. I think the key question is going to be whether the Democratic senators choose to filibuster Judge Gorsuch. Of course, if they decide to filibuster him, it would then require a commitment to continue to filibuster whoever President Trump nominates until there's a moderate that's picked. They also know that if they filibuster, then Senate Republicans, by majority vote, could change the Senate rules to eliminate the filibuster. In fact, yesterday, President Trump urged Senate Republicans to use the so-called nuclear option and eliminate the filibuster should the Democrats choose to filibuster. Now, I just told you I don't like making predictions, but I'm going to give you my prediction. I think that Judge Gorsuch will be confirmed for the Supreme Court, that the Democrats will make a lot of noise, there'll be a lot of objections, there'll be a lot of votes against him, but ultimately there won't be the votes necessary for a filibuster. Neil Gorsuch is 49 years old. If he remains on the Supreme Court until he's 90, the age at which Justice Stevens retired, Neil Gorsuch will be a Supreme Court justice for another 41 years. That's the effect of the November 8th election on the long term for the Supreme Court. But the fifth and final point that I want to talk about is the long-term future of the Supreme Court. Neil Gorsuch replacing Antonin Scalia to a large extent restores the ideological balance on the court to what it was before February 13th. I predict in the vast majority of areas, if there's a Justice Gorsuch, he'll vote the same way as Justice Scalia would have voted. In fact, there might be some areas where Justice Gorsuch is more conservative than Justice Scalia. Justice Scalia was often a pro-free speech justice. You might remember that in the two cases that found flag burning to be protected by the First Amendment, they were each 5-4 with Justice Scalia in the majority. Justice Scalia was often in dissent in recent years, together with Justices Ginsburg, Sotomayor, and Kagan, with regard to the Fourth Amendment and want to expand protections of privacy. Justice Scalia was the leader on the court with regard to expanding the rights of criminal defendants under the Confrontation Clause, the so-called Crawford versus Washington line of cases. So it's quite possible that there will be these areas where Neil Gorsuch is even more conservative. But I think the real ideological shift on the Supreme Court will come if Justice Ginsburg or Justice Kennedy or Justice Breyer leaves the bench in the next 4 years. Did you know that since 1960, 78 years old is the average age at which a Supreme Court justice has left the bench? As we're together now, there are 3 justices who are 78 or older. Ruth Bader Ginsburg will turn 84 on March 15th of this year. Anthony Kennedy will turn 81 on July 23rd. Stephen Breyer will turn 79 on August 15th. If even one of these justices leaves the bench, then there will be 5 justices on the court to dramatically change the law in many areas. I believe there will then be 5 votes to overrule Roe versus Wade and allow states to do whatever they want with regard to regulating abortion. I believe there will be 5 votes to eliminate all forms of affirmative action in education, contracting, employment. In the criminal law realm, I think there will be 5 votes to eliminate the exclusionary rule as a remedy for the Fourth Amendment. I think there may very well be 5 votes to overrule Obergefell versus Hodges and eliminate the constitutional protection for marriage equality for gays and lesbians. And it may very well be that the Democrats will decide not to fight as hard against Judge Gorsuch, recognizing that it's the next vacancy that could truly change the ideology of the Supreme Court, creating the most conservative court that there's been since the mid-1930s. I tried very hard in my remarks this afternoon to not be political. That's not why you brought me here. But I think if the last 2 weeks shows us anything, it's that now more than ever, lawyers are going to be crucial. Now more than ever, we're going to need the federal courts and the Supreme Court to protect our rights. Thank you so much.